Good morning, everyone. Welcome to a New Hampshire Business Review webinar. I'm Ernesto Burden, the publisher of New Hampshire Business Review. It's a pleasure to be here with you this morning. Today, we have a topic that is timely and crucial, and I think the discussion is going to be well worth your time. We're talking about critical updates in healthcare law and enforcement priorities for 2025. We're going to be talking about the dramatic developments in technology and sweeping changes in leadership at the federal and state levels, which all point to shifting priorities in healthcare law and enforcement. We have a webinar sponsored by Sheehan Finney today, and we have some great speakers, including speakers from Sheehan Finney, as well as from Healthcare Practice Group of Barry Dunn, McNeil and Parker, LLC. So our speakers today, Andrew Isles with Sheehan Finney, Amy Crafts from Sheehan Finney, Patrick Queenan from Sheehan Finney, and Regina Alexander, who is with Healthcare Practice Group, Barry Dunn, McNeil and Parker, LLC. With that, let's jump in right away because there's a lot to talk about. First up, you're going to hear from Andrew, followed by Amy, Patrick, and Regina. Afterwards, we'll be back to take some questions and answers. And so make sure that you're putting your questions in the chat, and we will get to all of them as we can at the end of this presentation. So right now, I'd like to invite Andrew to jump on screen, and I will leave and let you get started.
Thank you very much, Ernesto, and thank you all for joining us this morning. We appreciate it, and we hope this is going to be informative in the relatively brief time we have. My name, again, is Andrew Isles. I practice healthcare corporate law at Sheehan Finney. I do a lot of work in healthcare transactions, M&A, compliance, and regulatory work associated with a variety of different types of providers. Let me just start off this discussion with trying to put some context into healthcare law and enforcement for the coming year. We've got a new administration in Washington, obviously. There's a desire to target fraud, waste, and abuse in all areas. And we have, as you know, a relatively new development, not an agency, not a strict congressionally appointed department, but an arm of the administration nonetheless, the Department of Governmental Efficiency, DOGE. We've got a new Secretary of Health and Human Services, RFK Jr., and we've got Dr. Mehmet Oz waiting in the wings to be confirmed as the administrator for the Centers for Medicare and Medicaid Services. And as I just mentioned, the background to all of these developments and is somewhat unknown at the moment. We do know that with respect to enforcement of healthcare statutes and regulations, prior to the Trump administration, the U.S. Department of Health and Human Services and the OIG and CMS could be characterized by relatively aggressive enforcement and I would say increased scrutiny of recipients of federal healthcare dollars, whether those dollars came through grants, contracts, or participation as providers in the federal healthcare programs. In fact, in the fall of 2024, in its semi-annual report to Congress, for the U.S. fiscal year 2024, the government collected over $7 billion in recoveries, 1,500 plus distinct enforcement actions were undertaken, and over 3,200 individuals and entities were excluded from the federal healthcare program system. And so we clearly, in the past, HHS and OIG have gone after fraud and abuse. And because there is a desire to eliminate fraud, waste, and abuse, it appears that these kind of enforcement actions will not let up. So that said, let me just lead off this program with brief overview of the laws that healthcare providers need to be concerned about as they structure various financial arrangements between other providers and with other entities and parties. And briefly, if a provider in any manner receives or is involved with an entity that receives payments for providing healthcare services from the federal government or through any other federally funded program, these laws and their admittedly complex regulations have to be considered. And these are the laws that the government uses in many measures to collect fines and penalties and enforce the regulations promulgated under these various healthcare programs. First of all, we have the famous self-referral law, physician self-referral law, also known as the Stark Law. For those of you who may not be up on the Stark Law exactly, it's a complex technical regulatory statute, but in essence, it prohibits certain key things with respect to what a physician can and can't do. In other words, if a physician has a financial relationship with an entity, meaning any type of entity, then the physician cannot refer patients to that entity for particular services called designated health services that are payable by a federal healthcare program, i.e. Medicare, Medicaid, TRICARE, and others. That's a long-winded way of saying if a provider is going to get reimbursed, i.e. paid by the federal government for providing services and has a relationship with the physician can't make referrals to that provider or that entity. There are exceptions to this, and this is where this law gets particularly complex and technical. And I can assure you that many hours at seminars have been spent analyzing these exceptions in this particular law. But briefly, these exceptions include things you might consider normal, such as bona fide employment agreements, personal service arrangements, lease of office space and retail or office space, lease of equipment for medical procedures, and relatively new exceptions have appeared on the horizon that were actually developed in part during the Trump administration or Trump.1 and effectively issued during Biden's presidency. These exceptions include have to do with value-based purchasing or value-based arrangements that are between a value-based enterprise and a physician. In other words, we're trying to get away from, or the government allegedly is trying to get away from fee-for-service payments and is trying to reward value instead of volume of healthcare. And so as I mentioned, these exceptions are technical and they require complete adherence. In other words, you either fall within an exception or you don't. And the Stark Law is what's called a strict liability law or statute, and non-compliance with it means civil penalties, and they're fairly draconian, up to $15,000 per service rendered, and up to 3 times the amount of the improper payment received for services that were provided in violation of the Stark Law. So, and also, of course, a provider can be excluded from participation in the Medicare and Medicaid programs. So it's a tough statute and a technical one. We also have the federal anti-kickback statute, also known as the Medicare and Medicaid fraud and abuse statute. And this statute is a criminal statute which prohibits anyone from offering or soliciting or referring or receiving any remuneration, which is simply a thing of value, in return for patient referrals or inducements leading to leases, orders, or purchases that are payable by a federal healthcare program. And so remuneration, as I mentioned, can be anything of value. It also can include and does bribes, kickbacks, free rent, meals and other things like that that are used to induce patient referrals to another party. Under the anti-kickback statute, there are many federal healthcare programs and involved, not just Medicare and Medicaid and TRICARE, but there are a number of them: VA services, Indian Health Services, railroad employees, National Health and Welfare Plan, a number of some obscure federal healthcare programs that come under the umbrella of AKS enforcement. And you know, these programs, these federal healthcare programs, cover the breadth of services offered. So what the takeaway is, nearly every good or facility or service that is potentially payable by a federal healthcare program is involved in this. So providers have to be concerned about the anti-kickback statute. On top of the penalties that can be imposed for violations of the Stark Law and the anti-kickback statute, there is also a law called the Civil Monetary Penalties Law, and additional penalty amounts can be imposed for actions such as presenting a claim that a provider knows or should have known was demonstrably false or fraudulent, presenting a claim that for an item or service that for which payment was made, but for the service never having been delivered, and you know, making misrepresentations or false statements in connection with contracts or applications to participate in federal healthcare programs. So these two areas are the areas that you know, we are concerned about, and when we address and try to put together deals and financial arrangements between parties in the healthcare space, and we try to ensure, of course, that contracts, arrangements, and agreements satisfy these complex, detailed, and extensive regulatory schemes that govern financial relationships between folks in the healthcare world. I think looking forward, there are certain areas that may be under regulatory scrutiny. These include physician compensation arrangements, and in particular, physician compensation arrangements tied to what I referred to earlier as value-based enterprises and value-based arrangements that reflect the government's attempt to transition from payment models based upon volume to payment models based upon value. I think in the future, we're going to see some clarification and or litigation coming from these new exceptions to the Stark Law. I want to just conclude with a somewhat arcane legal concept for the uninitiated, but I think it bears mentioning because I think it will perhaps affect some compliance decisions and some compliance strategies going forward. For many years, about 40 years, CMS, as well as other federal agencies, operated under a doctrine of legal interpretation known as the Chevron doctrine. And essentially that provided that an agency's interpretation of a statute and the agency's rulemaking conducted under that statute should be accorded deference. In other words, courts had to give deference to CMS in its enactment of rules applicable to the Stark Law and the federal anti-kickback statute based upon CMS's interpretation of the law as Congress wrote it. Now, however, things have changed. Courts do not have to do this and have been instructed by our Supreme Court, our U.S. Supreme Court, not to do this. In a case issued in 2024 called Loper-Bright, which is now the law of the land. Courts get to exercise their independent determination as to whether an agency has acted within its statutory authority. And so now the courts will ask, what is the overall best interpretation of the statute in enacting rules under it, not in what is the agency's reasonable interpretation of the statute. And that's a significant difference. Loper-Bright involved a case involving the Atlantic fishery, herring industry, and the National Marine Fisheries Service issued a rule that required fishermen to essentially spend in the range of $700+ to monitor, to conduct sea monitoring programs. And the U.S. Supreme Court overturned the lower court and said that the Chevron doctrine giving credence to the National Marine Fisheries Service needed to be overturned. So it appears far removed from healthcare enforcement and regulation, but it's not. The result of the Loper-Bright case is that we may see challenges to CMS's interpretation of the Stark Law and the OIG's interpretation, Office of Inspector General's interpretation of the anti-kickback statute. Because of the higher bar now to justifying particular regulations that have been posed on healthcare providers and other entities. We can expect, I think, to see challenges to CMS's authority to promulgate certain Stark regulations. And we will see, and I think plaintiffs, meaning healthcare providers, may contest particular decisions or enforcement actions by CMS. So we may have reduced deference to CMS interpretations. We probably will have increased judicial scrutiny of the regulations promulgated by the Health and Human Services Department. And we may end up with congressional action, believe it or not, to define ambiguous terms in statute. I think that we could certainly see CMS issue more formal regulatory opinions or formal rulemaking and not rely on OIG advisory opinions or what's called sub-regulatory guidance. So as a kickoff, those are the rules and laws we look at when constructing transactions and looking at financial arrangements between entities. Providers are going to have to keep tabs on these developments in assessing their compliance programs. Now I'd like to pass the session over to Amy, who I think will give us a little bit more update into and dive deeper into some of the details, particularly with respect to the False Claims Act. Amy?
Thanks, Andrew. Good morning, everyone. My name is Amy Crafts. I recently joined Sheehan from the Massachusetts Attorney General's office, where I served for 10 years, including as chief of the False Claims Division, where I supervised investigations and litigations involving the State False Claims Act. So I'm going to spend the next few minutes talking about the False Claims Act, which is one of the most commonly used civil enforcement tools to combat healthcare fraud. There's a federal statute, the False Claims Act, and most states have enacted statutes that mirror either the language or the intent of the federal act. The federal act is enforced by DOJ, the Department of Justice, through either Main Justice in DC or through U.S. attorneys' offices throughout the country. In the healthcare fraud context, they're focused on Medicare and other federal government healthcare programs. And at the state level, the state false claims acts are enforced by state AGs, and in the healthcare context by Medicaid fraud control units, which are focused on fraud relating to the Medicaid program. And these efforts have brought tremendous success over the years. DOJ recently issued statistics for fiscal year 2024, and False Claims Act judgments and settlements totaled $2.9 billion, and of that amount, 1.67 billion related to healthcare fraud. So involving managed care providers, hospitals and other medical facilities, pharmacies, pharmaceutical companies, laboratories, and physicians. And with the change in administration, I think it's likely that false claims enforcement could look a little bit different for the next 4 years. Before I get into that, though, I want to focus on a few key points related to the False Claims Act that, after having enforced the act for the past 10 years, sort of strike me as what makes it a very powerful enforcement tool. So the first issue I'd like to highlight is the fact that the False Claims Act covers a wide range of conduct. So I'm going to highlight a few that were most commonly used in my experience. One way to violate the act is by submitting false invoices. So this could range from upcoding patient visits or billing for services that weren't provided. In this context, the actual document that is submitted to the government is false, and the false claims liability attaches to that document. Even if the invoice is accurate, however, a company could still be held liable if another important document or representation is false. So, for example, many government contracts require certifications that the contracting party is abiding by applicable laws or by contract provisions. If that certification is false and it's an important enough representation, that also could bring false claims liability. Another way to violate the act is what we call a reverse claims theory of liability. And here it applies if an entity improperly withholds money or property that's due to the government. So think about if an entity owes money to the government, or if an entity receives an overpayment from the government and doesn't return it in a timely manner. And then finally, we saw a lot of procurement fraud that we investigated under the False Claims Act. So in this situation, an entity might make a misrepresentation or a false statement in their bid for a government contract. And if that false statement is significant enough, then it can bring False Claims Act liability. So this isn't a comprehensive list, but I think it's sort of the takeaway is that there are many different ways to violate the statute. And in fact, the number of different ways really gives the government the ability to be creative in thinking about how conduct they view as problematic can fit into the False Claims Act. The second point I wanted to highlight about the False Claims Act is that it financially incentivizes whistleblowers to bring cases to alert the government to alleged fraud by awarding the whistleblower a percentage of any settlement or judgment. Depending upon the circumstances of the case, that percentage can range from either 15 to 30% of the total settlement or judgment. These are big cases. That's a lot of money that a whistleblower can receive if they bring a case to the government that ends up in a financial recovery. So the whistleblower files what we call a qui tam action. Qui tam is a Latin phrase. It means who sues on behalf of the king as well as for himself. So the whistleblower is suing on behalf of him or herself and on behalf of the government. The case is filed under seal, allowing the government time to investigate the allegations, and that seal period can be and often is extended by a judge at the request of the government. And once the government concludes its investigation, it has a few different choices. It can move to dismiss the case. That standard is very low, akin to a plaintiff voluntarily dismissing a case before an answer or other responsive pleading is filed. It can move to intervene, which means that the government takes over the litigation of the case on behalf of the government and on behalf of the relator, the whistleblower. Or it can decline to intervene, which means not that the case goes away, the case remains, but whistleblower counsel is able to pursue it on behalf of the whistleblower and on behalf of the government. And the reason I highlight this provision in the statute is that whistleblower cases are actually very common, especially at the federal level. They're becoming more common at the state level, but at the federal level, in 2024, 979 qui tams were filed at the federal level. And this is the sort of the critical fact. Of the 2.9 billion I mentioned earlier that the federal government received for False Claims Act actions in 2024, 2.5 billion of that was related to qui tam actions. So it's a huge percentage of the cases that the federal government pursues. The third and final point I want to make about the False Claims Act is that it's a statute that makes it more expensive to break the law than to comply with the law. The financial ramifications are enormous. So if the government wins at trial, the defendant is mandated to pay 3 times the amount of damages. And in addition to that, a penalty for each false claim. So you can imagine in a situation like an upcoding case where every invoice that's submitted to the government is false, there would be a penalty attached to each one of those invoices. And the penalty range is set by the statute, but it's subject to inflation. And in 2024, the penalty range applicable to a false claim ranged from $14,000 to $28,000. So that range applied to each and every false claim that's submitted to the government. You can imagine that adds up very quickly. The defendant also must reimburse the government for attorney's fees and costs of investigation. And this huge financial exposure is one of the main reasons why False Claims Act cases are oftentimes resolved short of trial, oftentimes resolved by settlement, where the defendant has the ability to negotiate. So turning to enforcement priorities, with the new administration, I think it's possible that False Claims Act enforcement in the healthcare context could look a little bit different than it has in the past. The administration is focused on immigration, on violent crime, on drug offenses. So it's an open question whether the same amount of resources will be dedicated to false claims enforcement as it has in the past. In addition, the new administration has signaled that it would like to use the False Claims Act to pursue things like DEI programs that aren't sufficiently eradicated by federal contractors. So whether or not the false claims resources will continue to be allocated to healthcare fraud matters is an open question, remains to be seen. If in fact that does happen, I don't see it affecting the amount of healthcare fraud enforcement under the False Claims Act, and I'll explain why. So typically what happens is a whistleblower will file a lawsuit naming both the United States and the affected states, alleging both Medicare and Medicaid fraud. In the typical sort of this administration context, typically the federal government, the federal prosecutors would lead that investigation. Medicaid fraud control units are perfectly equipped to step in and take over any investigations that the federal government does not have the resources to do. In addition, even if the government were to decline to intervene, the whistleblower bar is also prepared to litigate these cases. Because we saw such a huge percentage of these cases come from qui tam filings, I don't anticipate that the number of cases will diminish. It just may be a little bit different in terms of who's leading the investigations or who's leading the litigations. Before I wrap up, I just want to flag one other False Claims Act related development that recently occurred in Massachusetts. So the governor just last month signed a new healthcare oversight bill. It takes effect in early April, and it's meant to increase transparency of private equity investments in the healthcare market following the Steward collapse. While a variety of state agencies were given increased oversight, I want to focus our discussion today just on the False Claims Act piece of it. The State False Claims Act was amended to add another way of being liable under the Act specifically for investors. So those with an ownership or investment interest in an entity, if the entity violates the statute, then the owner or investor is also liable. What's important here, I think a couple key takeaways. One, the owner or investor does not have to have participated in the alleged fraud. They just need to be aware of it. And to be aware under the False Claims Act isn't just to have actual knowledge. It also could be deliberate ignorance or reckless disregard. So as long as an investor was a little bit more than negligent in knowing about the violation and not reporting it to the Commonwealth, the investor, sorry, to the government, the investor can be held liable. And secondly, this particular development, this amendment to the False Claims Act, it has been talked about in terms of this healthcare private equity law, but in fact, it's not limited to healthcare companies. It's a much broader amendment that applies to all owners and investors. So something to be mindful of even outside of the healthcare context. So to conclude, while I expect that False Claims Act enforcement will continue at the same level, I won't be surprised if it looks a little bit different, if more investigations are led by either state AGs, Medicaid fraud control units, or by whistleblower counsel. And with that, I'm going to turn it over to Patrick Queenan, who is going to speak about criminal enforcement.
Good morning, everyone. My name is Patrick Queenan. I work at Sheehan Finney out of our Boston office, as well as out of Manchester, New Hampshire. However, I cover cases and investigations all over the country. And how I come into play, I was a state prosecutor for the Attorney General's office in New Hampshire. And then most recently, I was a federal prosecutor for the US DOJ fraud section, and specifically in the healthcare fraud unit, in which I worked investigations and prosecutions of criminal offenses throughout the country. In fact, including Miami, Houston, Los Angeles, the major markets for healthcare fraud, and also started doing some work here in New England before I left to rejoin Sheehan Finney. And so where I come into play is if federal investigations touch you as an individual or your companies, and that could be in many forms. It could be in a subpoena, a CID, or a civil investigative demand, which is requesting records and information, search warrants that could be executed on electronic medical records or on physical locations, target letters informing individuals or entities that they're the target of a federal investigation, or federal agents come to your places of work and want to speak to your employees and are conducting investigations. I also work in matters involving special investigation units for commercial payers that will be investigating fraud, waste, and abuse on behalf of those private payers. And so cases I get involved in involve the US DOJ from across the country, as well as the local US attorney's offices here in New England. And they partner with the FBI, HHS, OIG, the Drug Enforcement Administration, IRS, criminal, Homeland Security, and then Veterans Affairs, Labor, and Postal. They all have their own officers of offices of OIG offices, and also Medicaid fraud control units. And expanded, and they are now operating in New England. They've almost doubled their force here, and they're bringing cases and running investigations in New Hampshire, Maine, and Vermont. And they are partnering with the U.S. Attorney's offices in Boston and down in Connecticut as well to bring cases that focus on healthcare fraud offenses. Healthcare fraud is a statute under federal law for providing false claims with criminal intent, wire fraud, money laundering, anti-kickback offenses, and also Controlled Substances Act violations for illegal prescribing. And these investigations can involve the entities as a whole from a corporate standpoint. They can involve the providers that work for those entities, the licensed professionals, the owners and managers of those companies. And as Amy just mentioned, there is a new focus on investment and private equity. And of course, Steward Health, has drawn more attention to that. And you can imagine that prosecutors and investigators will draw some interest if they're seeing some private money come in there to ensure it's not profits over patient care. And so criminal cases that start here, sound like, well, I hope I never get involved in a criminal case. And I certainly hope that is the case, but you don't have to be a target to kind of get sucked in. You're a depository of records, and they, may ask for information or records from you. But criminal cases that start sometimes don't end criminal, and they turn civil and regulatory. So the more active the criminal prosecutors are, the more cases and investigations get brought even on the civil side, in my experience. So we've talked a little bit about some of the changes with the administration, and of course, it's a tremendous amount of news flowing about the priorities shifting to immigration, combating the influx of fentanyl, and prosecuting drug cartels. And in fact, a lot of white-collar prosecutions regarding bribery or cryptocurrency, those are no longer a priority. Healthcare fraud, however, based on everything that we're seeing, that we're hearing, it's going to be not only business as usual, but some of those other white-collar resources now may be devoted to combating fraud, waste, and abuse, especially in light of this new government agency or entity that was referenced earlier, the Department of Government Efficiency. It is an easy sell for healthcare fraud prosecutors and investigators to ask to stay fully resourced or even receive more resources, because they're net positive. They're in the black for the government. Prosecutors and investigators bring back money into the program. I think Amy may have mentioned that in fiscal year 2023, which is according to a report that just came out in December, the government reported that it covered $1.8 billion for the Medicare Trust Fund and for Medicaid that came from these investigations for fraud, waste, and abuse. And that's just a fraction, because the Medicare program has 68 million beneficiaries enrolled. It eats up it costs $1 trillion or more, and it's about 17% of the gross domestic product. And Medicaid is another $870 plus billion. And so 1.8 billion is a lot, but you can see that fraud, waste, and abuse, if more resources are devoted there, which could be the case, that there will be more investigations because there's more, money to offset losses, the way that the Government Efficiency Office is looking at it. And so just in this new report, we learned that in fiscal year 2023, there were 800 new criminal cases involving healthcare fraud that were opened, and there was about 770 new civil healthcare fraud investigations. We're in the midst of the new fiscal year, and so we anticipate, based on these trends, that those numbers would probably either stay the same or even grow for the reasons we just discussed. And the priorities for now, based on the cases that we're seeing, continue to involve telehealth. There's a focus on telehealth and illegal prescribing. There's a prominent case that was charged with a lot of corporate actors that's pending right now in the Northern District of California, involving a company called Dun. There's a lot of focus on addiction treatment and recovery, laboratory and diagnostic testing, durable medical equipment, home health and hospice has been active for a while, and those will continue, because a lot of these investigations, they're data-driven. And so they're going to look where the dollars are and look for the outliers. And that could involve nursing home services, pharmacy, and opioid prescriptions. And of course, mentioned a few times already, in light of the Steward case, looking for the mix of for-profit and private equity within the healthcare space. And so because these are data-driven, DOJ has a data team that's providing reports to folks on the ground to see where they're going to deploy resources and whether or not to open an investigation. And so it may be the case that investigations are opened in the first instance on data alone, and data alone doesn't tell the whole story. And in fact, in many cases, there's completely innocent acting, there is legitimate healthcare services being provided, but because of a business model, it draws attention with the investigators because of the data. And so if your entity, is somehow pulled into the mix of these enforcement actions, we're here to help guide you through that. And that includes also, as I mentioned at the outset, special investigation units from commercial payers. This isn't like an audit in which we're asking for records. This is something different. SIU investigators that work with commercial payers, they have a little bit more tools to use, and they also make referrals to law enforcement that can start broader, government investigations. And so some of the tools that those investigators use as well is payment suspensions, where essentially they're now coming in and saying, hey, we want your records, we want to take a look. But while we're looking, we're going to suspend your payments and your cash flow is going to stop. And so, we're seeing some of that. And so if special investigation units, come into your entities or impact your providers or yourselves, please give us a call and we're happy to help with that. Well, I'm going to turn it over to Regina, and I'm sure you're happy to not have to hear from another lawyer. And Regina Alexander is going to give you a little bit different of a perspective. She's over at Berry Dunn. So thank you for your time, and please call. Happy to talk through any of these issues if they come up.
Thank you so much, Patrick. And as you indicated, I am the only non-attorney here, so why am I here? As you mentioned, I am from Berry Dunn, full service assurance tax and advisory firm headquartered in Portland with an office right there in Manchester, New Hampshire, as well as throughout the country. And I lead within Berry Dunn's healthcare practice group, I lead our healthcare compliance practice. And compliance professionals, non-attorneys, we're often called upon to support attorneys in the matters that Andrew and Amy and Patrick alluded to, giving the perspective of folks that have sat in the seats and are now consultants within healthcare organizations to help defend the clients against False Claims Act allegations, whether civil or whatnot, and provide that kind of expertise to look at the same data and poke holes in the government's case, or help organizations that would like to strengthen their compliance programs in support of perhaps not maybe ending up in that situation in the first place. So not to be repetitive, but we have had a lot of discussion about healthcare enforcement generally and how if I had to look at a crystal ball, it's not going to you go where the money is, and the money is in healthcare. When I was looking at the figures, 2023 was the most significant, highest number of settlements and money collected by the DOJ through these types of investigations into healthcare fraud, waste, and abuse. And in 2024, it increased by 30%. So it's not going anywhere. Amy spoke a lot about whistleblowers. And even if the federal government doesn't pick up a case or, takes up the case, lets up the gas, from a compliance perspective in your organizations, whistleblowers are something that sometimes happens because internal staff come forward and they bring up an issue and it's not responded to. So just to address that idea of a practical takeaway, strengthening your compliance program and having an open lines of communication so staff don't feel like I'm going to get retaliated on can save you a lot of trouble with a staff member that maybe is ignored and decides to take another route to have that what they feel is the right thing addressed. So there's just a practical takeaway on the fly. Both as Patrick and Amy highlighted, the targets have been both perennial with some newly emerging targets. We've had laboratories for some year, home health and hospice, specialty pharmacies. Behavioral health is both at the Medicaid and Medicare contractor level has been a focus for years, as well as telehealth, as more telehealth services were utilized starting during the pandemic, and that hasn't really let off very much. behavioral health in particular is vulnerable just because of the type of service that it is, and it's reimbursed based on time. So speaking of the data analytics that Patrick was talking about, time-based services have to be documented in a particular way. So even though a service of value was provided, then retrospectively, that's where you come in with the investigations. Just to add, also Patrick mentioned data, right? So I say, show me the data, show me the money is what the attitude towards that is. And one great example about that is during the pandemic, we had a lot of money flowing out in incentive funds. We had the Paycheck Protection Program that even, healthcare organizations, non-healthcare organization, it really helped a lot of folks out, but a lot of money flowed through there. However, wherever the money is, sometimes there is both accidents and unintentional things happen as well as fraud. So the Pandemic Analytics Center of Excellence, PACE, was created by the Pandemic Response Accountability Committee. And it's a great example of how the government has developed tools and data analytics to try to identify where potential fraud may exist. So PACE is an analytics hub of data scientists and investigative analysts that specifically look to identify potential fraud with pandemic relief programs such as the Small Business Administration's Economic Injury Disaster Loan Program, as well as the PPP. And PACE is a centralized resource that can be utilized, and it's really powerful, and the DOJ accesses it. And PACE offers data management, capabilities, investigative lead generation. And one of their core benefits has been the ability to access public and non-public data and share across enforcement agencies. So there's a lot of reports in the news about the use of data, right? With the new initiative out of the current administration with the Department of Government Efficiency, but a lot of these tools already do exist. So just as an example with PACE, there's access to 47 government public and non-public data sets within it. And there's memorandums of understanding with 47 different IGs. So it's important for healthcare providers in particular to note that the use of language in the development of PACE, it's to detect and prevent improper payments and fraud across all programs. So whether you're a non-healthcare entity that participated in PPP or you're a healthcare provider that received certain pandemic era relief, it's just important to know, as Patrick highlighted, sometimes it just starts with data, and then it's incumbent upon the target of either an investigation or some kind of demand to come up with the documentation to support that data actually doesn't indicate fraud or abuse. I also appreciate that we brought forward the issue of not-for-profit and for-profit. I like to say it's a tax status. If we're going to talk about healthcare organizations in particular, quality care can be delivered in any setting, but when we're looking to our crystal ball here, we can all expect obviously greater state level regulatory scrutiny of transactions of facilities, hospital transactions in particular. Recently, the New Hampshire AG has approved the sale of a not-for-profit hospital to a for-profit entity. Often these transactions are happening because hospitals, need investment, additional resources, various other circumstances. And I'm sure the audience is well familiar. We've mentioned the Stewart case. I am based out of Barry Dunn's Glastonbury, Connecticut office, even though I have clients throughout northern New England and down in southern New England. The Prospect Medical bankruptcy, it's the second largest health system with a private equity history to declare bankruptcy in the past 2 months, the first being Stewart. Prospect's a 16 hospital system headquartered in California. And as of their bankruptcy filing, they had $2.3 billion in outstanding liabilities. I have a client caught up in this issue, but they have over 100,000 creditors, and they have 3 states, Rhode Island, Pennsylvania, and Connecticut, with hospitals that are basically needing to figure out what comes next. But what they have in common in those 3 states is each of the groupings of hospitals are going to go likely from a for-profit entity back to a not-for-profit, just based on the circumstances. For example, the 3 hospitals with their fate in question in Connecticut, there's been negotiations going on for well over a year with a large academic medical center down here, but they broke down with both organizations filing suit against each other during the negotiations. But so these hospitals may be auctioned. We're still trying to see. You know, there's the new laws in Massachusetts that are meant to put a little bit more scrutiny over this transactions generally to for-profit, but hospitals in particular. But again, in 2024, it's not just the Massachusetts law. The DOJ signaled an increase in scrutiny of private equity and venture capital firms investing in the healthcare industry, including the potential False Claims Act liability that Amy talked about, because the theory was that the investors of the firm may influence patient care directly by providing directions on the business decision or whatnot. And the feds have joined several lawsuits in that regard. What we see in a compliance perspective and advising, our clients that may be making this transition, that just because you've changed from a not-for-profit to a for-profit, or even going back, you still need to invest in the same policies, procedures, internal culture of compliance that prevents whistleblowers. So that's pretty much the three topics I wanted to cover. And I think it's time, Ernesto, to open it up to some Q&A.
Thank you. Yes, thank you, Regina. And if everybody wants to jump back on, we have some questions from the audience here and a couple minutes to answer them in. I'm going to start from the top. So this may reference all the way back to Andrew's discussion, but I think both of these questions may also be relevant for everybody. So feel free to raise a hand and jump in. The first one was, when we discuss payment models based on value, as currently defined, I have to question the meaning of the term value. Some of the programs applied through CMS seem to be using rather arbitrary definitions of what value means. Some aspects are contrary to what patients want and what is meaningful to them. So I will open that up to whoever would like to tackle the value question.
I will try to take a quick stab at it. Essentially, the commentator, the questioner is right. Very deep in some of the details about value-based purchasing or value-based enterprises are various definitions of what value is based on federal that is reimbursed, or that federal healthcare dollars pay for. I think the short answer is that, as is evident from the discussion, there's so much money in the system that the government wants to try to build some enticements, efficiencies, and carrots into the system to reward practitioners, hospitals, providers, to provide the best care possible for the lowest amount of money. And then the thinking is behind the scenes that rather than paying for volume, which might not result in better care, better quality, the government should pay for value-based outcomes. And the commentator is right. How is value measured in that system? It's complex, but the idea, again, is to try to reward good work in healthcare and not just a lot of work in healthcare. But Regina, in particular, may have some thoughts on that question.
I do. I've been doing this over 30 years. So I have two levels of thought on this. Value, I agree with the question, is there's different perception of value, what patients want. And people often say healthcare is complicated. Some of these measures are coming from long-term studies on quality, NCQA standards, different other councils that have come together, best practices. But in reality, like Andrew says, it is ultimately to try to, it's another effort to try to reduce the costs. The issue is at the organization level, right? You have regional differences, the practicalities of trying to standardized supplies, all the things and the type of care that you provide. So reducing the variation to improve the outcomes. My practice at Berry Dunn has been involved with several accountable care organizations, either for compliance or other quality initiatives. And it's extraordinarily difficult, even among a coalition of the willing, we'll call it, of organizations that want to join an ACO, improve quality, meet these metrics. It's difficult, to your point, because sometimes it's not what the patients want. I want to think about anyone that went through the meaningful use period and the HITECH Act and the incentive programs for adopting electronic health records. Many of the standards that you had to meet and report on, some of them seemed very arbitrary and not necessarily really defining what really using electronic health record in the day-to-day meant. So very sympathetic to the question. I hope it was somewhat helpful.
Did anyone else want to touch on the value question? All right. The one additional sort of follow on to that question that occurs to me is that does the nature of value change if the nature of what is perceived to have been good healthcare, if people in the administration currently have a different perspective on that? And I'm thinking about things like mental health treatment, SSRIs, vaccines, does that change the nature of value? What should people be thinking about down the road?
That's a great question. I like that add-on. Yes, but healthcare, anyone that's involved with healthcare knows it moves glacially. It'll take time. There's rulemaking processes, you can cut through it, but there are best practices that have come about over years, but you may see some of the measures change, or maybe even complete programs be put on hold for reevaluation based on the perspectives of the new administration. That's what my crystal ball says.
Okay. Another audience question. While much of this references Medicare, Medicaid, TRICARE, et cetera, as federal programs, do these laws and rules also apply to the healthcare marketplace because it might provide an enrollee with a federal subsidy?
Yes, I think you should assume it does, because when you say might have a federal subsidy involved, if federal healthcare dollars are in the system in any fashion or as part of the payment, I think a provider involved in that or other entity involved in some portion of that needs to be cautious and needs to assume that the laws that we were addressing in the past hour certainly might affect or come into play. Both certainly the False Claims Act, anti-kickback statute, Stark, civil monetary penalties law, and I think those, the careful analysis would ask to what extent and are federal healthcare dollars being used to make some type of payment.
Okay, we have in the minute we have left, I'm going to ask one more question, which touches on everybody spoke about data to some degree. It's has been sort of at the heart of the discussion, really. How does the use of AI, both on the regulatory side, but also in the healthcare side, impact the importance of data, and does it potentially introduce new risks and pitfalls for providers?
I can jump.
Yeah.
So data's been used for a little while, but it's been more manually parsed. AI makes it quicker for the large amounts of data, claims data. We have electronic health records, mandatory reporting. It speeds up the ability for the humans on the other side that are monitoring that data to look for trends that typically would indicate potential fraud, waste, or abuse. So what it's important for the healthcare provider side or any entity that is providing data to the government, submitting claims, look after your own data hygiene, because now it's faster and it has more, there's just more sophisticated tools in there to detect potential trends. So your own data hygiene is probably the most important thing practically.
All right, well, that feels like a good note to end on. Beware your own data hygiene. Thank you, Regina, Andrew, Amy, Patrick. Thank you to everyone who joined us today. I'm Ernesto Burden. I'm the publisher of New Hampshire Business Review. And on behalf of Business Review, I'd also like to thank Sheehan Finney for sponsoring today's webinar. Hope everybody is staying warm out there and enjoy the rest of your day. Thank you.
Thank you.
Thank you.
Thank you. Bye now.